Tune in to Talking Law with attorney Darrell Oneal and a special guest host, attorney Jerome Payne. Live TV talk on your digital device, on Roku, Fire TV, and Apple TV. Download the SVP TV app right now. Check us out every Tuesday on Comcast Cable, Channel 17.
Welcome to Talk Law with Darrell Oneal. I'm your host. I got my main man with me, Jerome.
What's up, Darrell?
Another day in the neighborhood.
Yes, sir.
This is time 2 for Facebook.
Hey.
And so, again, Facebook, if you're watching, YouTube Live, if you're watching, hey, call in, ask a question, look at whatever. We can answer those things right now.
That's right.
I think if you have Fire Stick, Roku, Apple TV, you can actually download and look at that live also.
But Darrell, you forgot to give them the phone number. So you told them to call, but they don't know the number to call.
Okay.
It's still on the wall.
Oh, yeah.
Yeah.
So it's 901-244-6874.
I know you're just dying to call in. Now that you have the number, we're waiting on your call.
Yeah. And so we also got to give our shout out to you.
Yes.
So, and I forgot. There's an app out there also that you can download.
That's right.
SVP TV app.
That's right.
So you can go to the Google App Store or the Apple Store, and you can actually pull that app down and then download and watch it live also from that app.
That's right.
Wherever you are, So, welcome to Little Rock.
Right.
Welcome to West Memphis. Welcome to Memphis, Shelby County. Welcome to Mississippi. Welcome to the great state of Missouri, Mom.
Hey, Mom.
So we were going to talk about arbitration.
Yes.
Jerome, the greatest opportunity for people to understand what an arbitration look like is when they watch those TV shows.
Darrell, you really did educate me on today, because I had no idea that those were arbiters who are actually the judges. Yeah. Okay.
Faith Jenkins is her name.
Okay.
Judge Faith Jenkins.
Okay.
She used to be a prosecutor, but she has a show called Judge Faith Jenkins.
I've seen her.
Well, she's not a judge. Yeah. She's never been a judge. Okay. She's an arbitrator that gets to wear the title because she's an arbitrator.
Okay.
So in some states you can use the title. I don't think in Tennessee, if you're an arbitrator, you get to say you're a judge. But I think in some states they allow, every state is a little different.
That's right.
Every rule is a little different. But Tennessee, they don't allow that specific, you actually have to have been or actually have to be an actual judge, I think, in order to assume that title.
To say that, yeah, I got you. Okay.
So to run that monitor.
So won't be no false advertisement.
And again, Jerry Springer,
right?
Never been a judge. Now he actually is a lawyer.
Yeah.
And he can get away with saying he's a judge because he used to be a mayor.
Oh.
And one of the things about mayors, you can also act as a judge.
That's true.
Then I think Steve Harvey has a stove. Now Judge Steve Harvey, he ain't even a lawyer.
but there, in some cases, you don't have to be a lawyer to be appointed as a judge.
Yes.
And so even in some of the appellate positions, don't require you to be a judge. Even a Supreme Court justice does not have to be a judge.
Yeah, because there's some states that elections are ran. You run for those elections.
Right.
Now, and some of them have a requirement that you have to have a law degree.
Okay.
I think Shelby County, for the juvenile court judge, I thought that there was some rule that they didn't actually have to be a judge.
For years and years and years, it was like it, but I think they changed the rule after Judge Turner passed away. Okay. Because he was not a lawyer.
Oh, I didn't know that.
No, he was not.
I never knew that.
No, but Dan Michaels is, because he and I went to law school together.
Yeah, I knew Dan Michaels is.
And
Curtis Person was.
And Curtis Person was a lawyer too, right. Because that's why on some cases he could not sit.
Turner.
Yeah, that's right. Okay. He had to have someone else to sit in those cases, because a lawyer has to be the one who hands down the certain kinds of sentences, because the person has to understand due process of law, have to understand what the limitations are, have to understand how to respect the rights of a defendant, and you only get those by being in law school.
I mean, I guess you could always read the rules And some people have that kind of skill, man. They can read them and then, synthesize them and be able to articulate
but the problem is they haven't been tested.
Yeah, that's true.
Remember?
Yeah.
You don't know what you know until you're tested on it, right?
Right.
Because when we go into those law school exams, we think we got it down. Or even when we're practicing, getting ready for the bar exam. Did you practice by yourself, Darrell? Did you study by yourself?
I did for the most part.
You didn't take a.
Oh no, I took a prep course.
You took a course, okay.
Yeah, I took because I came from St. Louis to here.
Oh, okay.
So I took that Barbary.
I took Barbary's too, yeah. But there's also writing examples on there too that you get a chance to and answer the questions. So it was tested. Is what I'm saying. All right.
Yeah, I put so much work in for study for that damn thing. But anyway,
but you passed the first time out, didn't you?
Yeah.
I passed the first time too. Now only what 85% of the people take the exam the first time will pass it or something. Do you have an idea what that?
Nah,
what that record is?
Nah, there's people. Look, man, I tell people all the time, whether you pass that mother the first time, second time, the 15th time.
That's absolutely correct.
If you pass it, you good.
And what's your title?
You're a lawyer.
Right.
And see, that's why,
that's exactly
if you graduated from law school with a 2.0 GPA
right.
or a 4.0 GPA, at the end of the day, you got a Juris Doctorate.
That's exactly right.
And if you take the bar and you pass, well, Tennessee, it used to be 125, 130, 135, and if you pass at the very bottom of the scale or you pass at the very top of the scale, at the end of the day, you get to practice law. And
the Supreme Court of Tennessee has determined that you know enough to wear the title, right? And that's how they give you the license to practice law. Right? And what's so beautiful about it too, there is that it's right there in the title, practicing law, that it's not a fixed career. You constantly are learning new things. You're constantly advancing new strategies, and so it's kind of like medicine too, isn't it? You practice medicine because things are changing daily. I'm glad we're going this route too, because all them horrible decisions that were made that affected the lives of African Americans down through the years, they're going back now trying to reverse all of those. Did you see that?
I see they're trying to correct some of them.
Yeah, did you see that? Yeah, I just saw it the other day. They're trying to go back and get them even removed. Plessy versus Ferguson. What is the one about marriage?
That's Lovey.
Yeah, Loving.
Yeah,
the Loving case.
That statute that was it misogyny?
Yeah, misogyny.
Yeah, that statute.
No, not misogyny. Miscegenation. Misogyny is against women. It's miscegenation or something like that.
That statute is still on the books in Virginia, so they never repealed the law. So that's always the problem. There is probably all kinds of statutes that are on the books here that people don't realize that have not been repealed. And what ends up happening is, as long as nobody is trying to use them, you can't really do anything because they haven't been repealed.
Oh, okay. I see.
And nobody's trying to enforce them.
Right.
But once somebody tries to enforce them, then you can have them removed as unconstitutional.
Okay.
So, because Loving is still good law. Ain't nothing overturned Loving.
It's still good law.
Yeah.
So someone could be prosecuted under it then?
Well, that's where you have to do. If somebody gets prosecuted under it, then you get to go back and do the constitutionality of it.
I got you.
Because I don't know that there was any statute that the U.S. put any statute in place that says that about marriage and races and all that stuff. They never did that. They never done that.
I think that's local stuff, wasn't it?
That was Virginia.
Yeah.
That was my understanding.
Yeah.
So when we talk about this arbitration provision or arbitration, like I said, the way you see it, when you see Judge Steve Harvey, he's acting as an arbitrator. Judge Faith Jenkins, she's acting as an arbitrator. Jerry Springer has never been a judge either. He's acting as an arbitrator, but he used to be a mayor.
Okay.
And because you are a mayor, you can be a judge. The honorable so-and-so when you was the mayor.
Oh, I see.
So,
Is Judge Judy really a judge?
Shinelin, I think she was a judge.
She was a judge?
I think Shinelin was a judge before.
Criminal court judge or civil?
I don't remember the specifics of it.
Because I know that the 2 judges that's on, what is it?
Hot bench?
Hot bench.
Yeah.
Now, 2 of those were criminal court judges.
Yeah, 2 of those were judges. And the black lady is an arbitrator. She wasn't a judge.
Okay.
The judge, I can't remember her name, Milan from People's Court?
Yes.
She used to be a judge.
Okay.
And her husband's a judge. So,
right.
So, you know, before they got on the bench. And of course, Joe Brown.
I was about to say
was
that.
A judge.
I was about to say that.
Was a judge.
Yeah.
But he was a criminal court judge.
And Joe was right here in the city of Memphis with us. And Joe was a pretty decent judge, wasn't he?
I did, you know, I never did. I don't do much criminal stuff.
Okay.
You know, if I'm doing your criminal stuff, you know, you're getting a treat. Because, you know, but anyway, that's a whole other issue.
But I like Joe because that's why that's why he became like a household name, because he was doing some innovative
that's what I heard.
Kind of sentencing.
Yeah, I've heard that.
Look, you can lock up folks all day long, Darrell, and we're still going to have a crime problem.
Right.
We have got to figure out a way to do something other than warehousing people.
Yeah.
Because what we found out is that when you warehouse one individual with a bunch of professional criminals, the one who went in then he comes out with more skills on how to be a professional criminal. Right. And so that's why we got to figure out a way to do better than what we're doing.
Yeah. And that's the reason why you see they have another case thing called the personal injury court. You know, Judge Brogdon.
Okay.
I mean, he used to be a judge. And what you do is you see a lot of stuff that's happening in there that won't normally happen in a regular courtroom.
That's exactly
because
right.
As an arbitrator, the judge or the arbitrator gets to set what the rules are. And you sign that you're going to be bound by whatever happens or whatever that decision happens in that court. You have agreed that you're going to be bound by whatever that decision is.
Okay. And so that's important too, because one of the hallmarks of our regular judicial system is that there is the right of appeal. Mm-hmm. So you're not bound by the decision of a lower court, so you get another opportunity to have it reviewed by a higher court.
Well, see, now we may have to agree or disagree. I think that a ruling by a lower court is binding. But I think what happens is you can get a review process.
Okay, so
the appellate court is just a review.
Well, let's say this, Darrell. It's binding, but it's not a final judgment. Otherwise, you couldn't appeal. Well, so it's not binding. Well, because it's not final.
Well, okay, so
right.
I think it is final.
Okay,
because in order to get to the Court of Appeals, you have to have a final
order.
That's
right. You're absolutely right.
So they will not hear a case that doesn't have a final order. But what they do is they review that final order or that final decision to see if there were some errors or some mistakes that were made. And then what their job is to review, to correct any errors or mistakes.
So it's a final order, but it's still appealable? It is appealable. Once it's final?
Yeah.
But you only have a short window to do it in.
Yeah. So what ends up happening is, so it's funny you say that. The way that works is the Court of Appeals doesn't have jurisdiction over a case
unless it's final.
Unless it's final.
I got you. Okay.
So, but their jurisdiction, the Court of Appeals jurisdiction, is limited. It's a 30-day window. Okay. So it's 30 days from the time that the actual order was signed into 30 days. So that is the only window for you to have. They would only have jurisdiction for a limited window. Okay. And if the order wasn't final, unless the court, it's Rule 54, the court says under Rule 54, we're certifying that this order is final. It's not final. Then they don't have any jurisdiction. Okay. But if it's a final order, they would only have an opportunity to get jurisdiction under a 30-day window if somebody files a notice of appeal within that 30-day window. Okay. If they file a notice of appeal on day 31, okay, the Court of Appeals has no jurisdiction. And unlike unlike some of these other statutes, you can't get an extension to file your notice of appeal late.
Really?
Right. So if you miss that 30-day window, you have to go
out.
Well, you're not out.
Okay.
You can actually go back to the court under Rule 60 and ask the court to redo the order for some reason, which gives you a new 30 days.
Really?
Yeah. You know, so there's got to be some circumstance. You just can't say, "Hey, Your Honor, I missed the 30-day window. You know, can you fix my order to give me an additional time?"
Well, is it what's the term we use? Ignorance.
Excusable neglect.
Excusable neglect.
Yeah. So,
but you gotta have a good reason.
You gotta have a good reason. So that's Rule 60.
Okay.
Rule 60, because Rule 59 stays that window, so it puts a hold on your time to appeal.
Okay.
Rule 60 doesn't. And Rule 60, you can use it all the way up to a year, you know, and sometimes you can even use it longer than that.
Really? Okay.
You know, but, you know, a prime example, I give you one, it's one of my cases. I was representing a guy, and it's appellate, so it's not confidential.
Okay.
The guy's name was Sean Tyus.
Okay.
And what happened is, we lost on a motion for summary judgment in one of those little counties. And I got home cooked in the county. So what happened is, the lawyer that used to work for me, she was transitioning from Nashville to Memphis.
Oh, I see.
And what they did is they sent the order, the final order, to her office in Nashville.
I got you.
They never sent the order to my office in Memphis.
Okay.
And she had transferred to my office in Memphis. And so what ended up happening is we missed the 30-day window to appeal. We filed a Rule 60 to say we should have that order set aside because it was sent to the wrong office, and defense counsel never sent it to the right office, never sent it to my office. And as a result of it, there was an excusable mistake or excusable neglect. And so the court did set it aside and then allow us to appeal. Now, he didn't want us to appeal because he knew we was going to win, and we did win at the Court of Appeals. That's why he didn't want us to appeal.
And that's probably why they sent it to the wrong, because they're required to serve it.
Yeah, I don't think this guy
did he do it on purpose?
Nah, you know, the lawyer, you know, really good lawyer, real good lawyer, real sharp lawyer. I mean, and there's nothing unethical about the lawyer.
And
I don't think he did it on purpose.
Well, and he knew he was supposed to lose, though, even in the little town that you win, right?
Oh yeah, he know I got home cooked.
Yeah, right.
You know, when the judge saying, you know, well, that case that you cite, man, that case, they're gonna give us some problems. us ain't appealing. I'm the one that, you know. But the problem with arbitration is final and binding.
Oh.
And I think there is a review, but that review is extremely limited. So I think you can get an appellate review, but it's extremely limited.
That seems kind of strange. So you'd have to then bring it back into the justice system to get it reviewed under some very strenuous rules.
Some limited circumstances. You know, some law, rule, regulation, or something like that. Because what ends up happening in a lot of these arbitration cases is you file your case in court, right?
Right.
The lawyer or the defense or somebody said, Your Honor, this shouldn't be here, it should be in arbitration. So they file a motion to dismiss it or to compel arbitration. The courts never dismiss it, they maintain jurisdiction. But they do stay it and then force you to arbitration.
Okay.
And then what happens is when the arbitration ruling is done, it comes back in the court so they can enforce the judgment of arbitration.
That's right. So you get a written ruling in arbitration?
You do.
Okay. And so that's really what happens many times with professional football or professional sports.
Yeah.
Whenever there's a disagreement about contractual matters, whether a person was suspended or not suspended, it goes to arbitration. Is that right?
It is.
And those arbiters, they come back many times with rulings that are they're binding on the NFL or the baseball association.
And I've seen a couple cases where the courts have intervened and stepped in and said, hey, your ruling had no justification or something like that. Or the courts, I can't remember whose it was, but the court stepped in and actually entered an injunction against the NFL and allowed this player to play.
Oh.
Because he was being suspended for something, and they entered an injunction to allow the person to play. But the problem is the NFL, their rule is that the final decision comes from the commissioner.
Yeah.
And so, you know, he's the one that issue out the ruling, and then he comes back and have the final ruling. And so, you know, they came back and try to argue about the, you know, it's an unfair process. Duh, y'all voted for that.
Right.
You know. So
one more thing. Now, is that how? I was just thinking about Kurt Flood. You remember how before he's the one who opened up arbitration in these matters, isn't he?
Flood. Okay, so no.
Before
Flood was the one that opened up. The ability for free agency.
Yeah, free agency. Yeah, okay.
For free agency. I don't think that was an arbitration issue.
Okay, yeah. But before then, once you sign with a team, you just bound to stay there, and then free agencies came about.
Right.
And so that's
he didn't benefit from it.
Of course, no. many times when we do things like that, the person who is the what?
He was the Kaepernick of baseball at that time.
Exactly.
He got blackballed and he was out of it.
He was out, and never ever got a chance to play again, did he?
Yeah, not that I remember as far as my history.
Right.
You know, obviously, Flood is that time was a little.
Ooh, that's a long time ago.
A little before my time,
but it changed the whole face of baseball. All of them,
yeah. And so, here's how that arbitration normally happens, Jerome. We see arbitration in two ways.
Okay.
We see TV arbitration, and that's the Judge Judy and all that other stuff. That's arbitration.
Right.
And then the other way we see it is, next time you go buy something, pay attention to it. And what it says on there, and you sign. Most people sign, don't even read it. And what it says on there, in the event that there's a dispute,
I'm guilty.
Yeah, you will be subject to binding arbitration.
And you may be in some other state or something too. There, once you
some of them say
California, you might be New York, right?
Going all over this place,
and you never even read it before, right?
Again, you know, if you read it. So I bought a car.
Right.
I think I told you about it.
I think you told me about it, yeah.
And they had a provision in there that says if I had a dispute with Toyota, I would go to binding arbitration.
Right.
I said, I will not. And the guy was like, well, you know, if you're not going to do that, we're not going to sell you the car. I said, all right, well, I'll take my toys and go home. You know, my money spends anywhere, so I'll go home. But I decided I needed, because I wanted to give my daughter my car.
Right.
And I would not have had a car,
right.
You know. So I said, you know what? And so what I put on the document is, sign this under duress.
Oh, okay.
And I put on there, I was told that if I didn't sign this, that I couldn't
purchase the car.
I couldn't purchase the car.
I got you.
So it gives me a loophole to say that the arbitration was unconscionable, you know, or you know, unfair, unbinding,
right?
You know. And so that's why you put some stuff like that in there.
And they accepted it like that?
Yeah.
They wanted that money, huh?
They wanted it. Because I really was, you know, had I had my car, because what was going on is I had no car.
Right.
I was giving my daughter my car.
And she already had it, and you just you had to have transportation.
I had to have transportation.
I got you.
So I would have not had a car. Yeah. So, you know.
Now let's move it on down to like the local fella who's at the used car lot.
Yeah.
When they say we're gonna let you drive this car off the lot, I don't think anybody's gonna sit there and read it.
No.
They're just gonna sign because they're so excited and be able to get the vehicle. But what we're trying to do is warn you that is it also in the black box there? It
is.
It's in the what we call that?
The signature.
No, it has the Miranda in the civil law Miranda.
Okay. Yeah, it should be all in that area.
Yeah, that's in that black box.
Yeah.
And it's raised type.
Yeah.
So you can't say that you were not aware that it was present. And many times we can win a lawsuit in civil court based on the fact that maybe there was a term in there that you did not see or something like that there. So it's very important that you stay on top of what you're signing.
So there's two things to look for in an arbitration agreement, or two things to pay attention to. And, you know, here's where people really go bad and go awry. if you're being sued by one of those creditors in General Sessions Court, and the judge asks you, do you agree with the numbers or not? I think the first thing you should say is, I don't know. I need to see the documents, and then I'll determine whether I agree. And what you need to look for when you look at that document, the contract that they're using to sue you under, you need to see the agreement that they bring in the court that you signed, whether or not it has arbitration provision.
But Darrell, how would they know to do that?
I just told you.
Okay, I got the document. Now, where is this? Where do I find this at?
It should be in, most contracts are broken down, or they're breaking down real simplistic.
That's very good.
And it's going to have
a heading.
It's going to have a heading that says dispute resolution.
That's right.
And normally the arbitration provision will be in there.
And it's going to have a default clause. It's going to have what? Default. Yeah. Arbitration. Or a contract for attorney fees there too, shouldn't it?
It'll have all that in there. Yeah. It'll say, and here's the language: in the event that you are in default or you fail to make payment, and we have to pursue you, we will be entitled to reasonable attorney fees for initiating this process. Is what it normally says.
That's right.
Now, the good contracts, if there is such, will say attorney fees will be awarded to prevailing party. Oh. Which means that either one of can win and get attorney fees. But most of them don't say prevailing party.
Why would someone why would the person drafting it draft it in such a way as to say prevailing party there?
The ones that do that are really trying to be fair.
Okay.
And there are some of those organizations and some of those places that set it up that way.
Okay.
But the other thing is, if it has in the contract or the arbitration agreement that you have to go to arbitration, but they can go in regular court, then that whole contract is invalid.
That's what I'm just thinking. I'm saying to myself, how can that be? Because that would be a unilateral.
It'll be illusory.
Yeah, because you don't really have a true contract. You're
not getting anything.
You don't get anything for it.
Yeah, they're not,
That's exactly
you're not getting anything. So anytime, these are things that, look, sometimes you just spend a couple dollars to let a lawyer review that. And as much as I hate to admit this out loud, when people come to my office and they schedule a consultation fee.
Right.
I charge them $100 consultation fee.
Right.
And sometimes if they have a little piece of paper or something that need to be looked at, I review it right then, even though they only paid $100 for a consultation.
Right.
Because really conceivably, I should be able to charge them for every minute that I'm really spending time.
Exactly right.
And it could be an hour or two.
Exactly right.
Now, obviously, I know exactly where I'm looking for.
Right.
I'll go right to that area, and then I'll say, hey, here's a problem with this contract. Now, if you want me to do more, it's going to cost you more.
That's exactly right there.
Kind of thing.
Yeah.
So.
And you should be willing to spend $100 to save yourself several $1,000s. You know what I'm saying?
Yeah.
So how much is it worth to you to make sure that the contract is not illusory? In fact, you do receive something. In other words, you receive consideration from your side and from the creditor side. And that's how you ensure that it's going to happen that way. It's having someone to review it for you.
And that's important, man. I mean, you want to set this thing up where and again, sometimes you just say, I want to go to trial. Because, when you see the thing that says LMV Corporation.
Right.
And you didn't sign no deal with
LVN.
LVN. You didn't sign no agreement with LVN.
Absolutely. You don't. So, in fact, you don't have no idea who LVNV is.
Right. So probably what they're going to have is a person that can attest that they bought the debt. They can't attest that it's your debt.
Right.
We bought this debt for something, and all you have to do to testify, that ain't my debt.
Right.
What's their response? Well, it is your debt. Prove it. I just told you that's not my debt. Right. I don't know anything about that. They don't have you. That's not my. You don't have my signature.
They do. They
most time they don't have anything.
If they come in for trial, they're gonna.
All right, y'all. Well, we talked about some stuff, and look, try to talk about arbitration and just awareness, arbitration awareness.
Exactly.
Look at the documents you sign and be aware of whether or not you're signing up some of your rights. All right. Thank you for watching the show. We'll see you back next week.
My name is Dr. Michael Vincent. I'm here to discuss the true epidemic in the black church, which is diabetes and obesity.
Watch Rebalance Your Body Naturally with Dr. Michael Vincent weekdays on the SVP TV channel.